contracts require offer, acceptance, and consideration, you may want to consider leaving that one out and simply talk about the specific rules relative to a rescission in the case where somebody didn't understand the nature of the transaction, or whatever it is. You don't have to go through a bar exam analysis, just the major cases there. And that ought to be it. And if you can get that down to 2 or 3 or less pages, you're better off. Okay, let's talk about the hearing itself. First, some general principles on what these hearings are all about. If you take a look at Code of Civil Procedure Section 1141.10, you get sort of the philosophy of what an arbitration hearing is all about. It's an important philosophy, so I'm going to read them. Subdivision 1 says, arbitration shall provide the parties with a simplified and economical procedure for obtaining prompt and equitable resolution of their disputes. Subdivision 2 says, arbitration hearings shall be as informal and private as possible and shall provide the parties themselves with the maximum opportunity to participate directly in the resolution of their disputes.
Rick, that sounds strangely like trial by combat. How do you interpret that?
When you hear that, it sounds like everybody's supposed to get in the room and yell and scream at each other. I read those because it sets the tone that you're supposed to have some degree of informality and some degree of cooperation and participation by the client. The other side of the coin, however, is that these things are court proceedings, and some of the formality and some of the ground rules and some of what you generally consider to be a court proceeding apply. And the key then is to balance. Obviously, we can't tell you as a general rule how to balance things. The point is simply you should keep in mind that in any arbitration proceeding, you've got two things competing with each other. One is the formality of a court proceeding. The other is the tenets set forth in the Code of Civil Procedure section. Just keep both in mind, and I think as you present these things, and the more experience you get with these things, you'll understand how they interact with each other. As a matter of fact, the best way of balancing the two competing concepts and of presenting the hearing is to put yourself in the position of the physics student who took a final examination. You should try your arbitration case in the same way, with the same approach that the physics student learned. The physics student I'm talking about, of course, is the one who did very well throughout the physics course that he took and answered the questions properly and did well on the quizzes, and comes the final examination, which was an essay test. One question: how do you measure the height of a building with a barometer? And you all know how to do that, so I won't take too much time on explaining that. You look at the air pressure at the bottom of the building, you go to the top of the building, you look at the air pressure, and there's a formula. That's how tall the building is. Well, the student didn't write anything on the paper, and the professor looked at this and was quite puzzled, because here was a good student who didn't even try to answer the question. So rather than summarily failing the student, the professor called the student in and said, "What's the problem?" And the student said, "Too many answers, couldn't think of which one to put down." The professor said, "What are you talking about? Give me one answer." And the student says, "Fine. You go up to the top of the building with a barometer and a bunch of string, and you tie the end of the string to the barometer, and you let the barometer down the end of the building, and then you measure how much string you let out, and that's how tall the building is." And the professor said, "Well, that would probably work, but I don't think that's what I'm looking for. Give me another way." And the student said, "Fine.